heard testimony and saw evidence today that's emotional, that might stir your passions. But I urge you to use the law, the facts, and your common sense to reach the truth. Now I know Miss Beckett, she told us that we're here today because of discrimination, but that couldn't be further from the truth. We're here today because Miss Beckett failed to remain consistent, failed to stay the course. Now I want to remember, Miss Beckett made the choice to enter the field of law. She knew the demands of the career that she was getting into. And she knew and I want you to remember that when she walked into this courtroom, she knew that she bared the burden in this case. The burden to prove to you beyond a preponderance of the evidence the claims that she has brought against Hyatt Healer. Members of the jury, there is simply not enough evidence to overcome that burden today. In a few moments, you're going to go in the back of that jury room and you're going to deliberate. You're going to have these jury instructions in front of you. And you're going to see that Miss Beckett had to prove that the main reason Hyatt Healer denied her promotion and ultimately ended her employment was because of her gender. She had to prove that she suffered an adverse employment action, that Hyatt Healer intentionally discriminated against her. And that's simply not true. Because we heard Mr. Healer and he explained the reasons why Miss Beckett was let go. He illustrated for you during his direct examination. And there was not one instance where Miss Beckett being transgender was mentioned, let alone a main reason for ending her employment. So let's talk about the factors about what really brought us here today. Factors like billable hours. Now, we heard that Miss Beckett had a pretty good track record. And while that might be true, we know that she took her foot off the gas. She failed to stay the course. In 2016, she billed 1,890 hours. That's only 90 hours more than what's required of a first-year associate. And she's on her 7th year at the firm. So the year that mattered most, the year that required the most dedication, and she billed nearly 310 less hours than what's required for an associate on track for partner. In fact, she billed nearly 400 less hours than she did the year in 2015. And we heard from Ms. Alvarez and Mr. Healer that Ms. Beckett was investigated for fraud. And while that investigation was inconclusive, while they tried to discredit that investigation, we know that there was some evidence of fraud. Enough so that a note was placed in her file, the hours were attributed to her legal secretary, and ultimately that client was refunded. And if you question whether or not she committed it, I mean, you have to remember, a 7th-year associate attorney billed nearly 7 times more hours than her legal secretary did for the same amount of work. Another instance that placed a negative mark on her record, another instance that took her out of favor from being considered for partner, another instance where she failed to stay the course. Factors like client development. We'll go to client satisfaction. We know that she was removed from a case, that she lost Hyatt Healer's biggest client. And while she tried to get up here and say that it was because she was transgender, we know that that's not the case. Because representation matters in the field of law. Representation matters especially when you want to represent clients in this courtroom. Because those clients' future are in her hands. And you heard Ms. Beckett when she was on this witness stand. She didn't think it was important for judges or juries to see how she was represented and representing her clients. Members of the jury, you're probably thinking, does a client really want an attorney to represent them when they don't care what judges think? When they don't care what juries think? No. Because we know that when you walk into work, it's not about what you want. It's not about your desires. And especially when her client's future is in her hands, it's about the client that she signed up to serve. And we know, we heard Mr. Healer, right? He was on the stand and he told us that Hyatt Healer is a client-first mentality firm. They have never not honored a client's request for a change in representation. And why is that? Because clients have the sole responsibility to decide who represents them. That's their choice. So when a client goes to Hyatt Healer and says, we want a change of attorney, that doesn't have anything to do with the intent of Hyatt Healer. Factors like client development. Now we know client development is important, right? Because without clients, I mean, there's no firm, there's no business. In fact, it is so important that when associates bill less hours to focus on client development, they understand, they get it. But Ms. Beckett, she went on this witness stand and she said that she billed nearly 400 less hours to focus on client development, but brought in less clients? Members of the jury, the numbers don't lie. Another instance where she failed to stay the course. Now, Ms. Beckett had to prove to you that she suffered adverse employment action. Again, their evidence misses the mark. They conveniently left out that just because an employee is unhappy with a result at work, that doesn't mean they suffered an adverse employment action. No. Ms. Beckett, she's allowed to be unhappy. She's allowed to be upset. But what she is not allowed to do is use this as an opportunity for an excuse for her own failure to stay the course. You heard about the up and out policy. It applies to all associates, no matter their race, no matter their gender. And it's used so that way new associates have the opportunity to make partner just like Ms. Beckett had. And we know that Hyatt Healer employs nearly 100 attorneys. So she had competition. And when she took her foot off that gas, her coworkers, they continued to steam forward. While we heard on this witness stand that Ms. Beckett was investigated for fraud, we didn't hear anything about her coworkers. While we heard that Ms. Beckett was taken off of a case and lost Hyatt Healer's biggest client, we didn't hear anything about her coworkers. While Ms. Beckett billed nearly 400 less hours, we didn't hear about her coworkers. And just because Ms. Beckett was unhappy with that result, I want you to remember, members of the jury, it was a result of her own doing. And now we know that Ms. Beckett was in an at-will employment relationship with Hyatt Healer when she was let go. What does that mean? That means that Ms. Beckett didn't need to have a reason, but Hyatt Healer gave her one anyway. She didn't need advance notice, but Hyatt Healer gave her 2 months. 2 months of pay, 2 months of benefits, 2 months of being able to stay on the firm's website to help gain future employment, and she refused. You also heard from Ms. Beckett's only other witness, Dr. Miller, as he corrected me, right? Mr. Miller took this stand, Dr. Miller, took this stand, and he spoke about pretext. He tried to discredit that investigation and Hyatt Healer. But I want you to remember, Dr. Miller only ever testifies for plaintiffs who sue their employers. He has testified in court 17 times and not one time for a defendant. And while Dr. Miller is a doctor, right, in employee discrimination cases in HR, he didn't review any of the work product or interview partners at Hyatt Healer. He didn't interview any employees. He didn't interview Ms. Beckett before he made his opinion. And so you might be asking yourself, why would an expert in human resources who knows that discrimination requires intent not interview a single employee at Hyatt Healer? Because Dr. Miller made his opinion before his investigation even started. And while Mr. Miller, Dr. Miller, and Ms. Beckett took this stand and talked about pretext, members of the jury, don't let Ms. Beckett use her transition as pretext for failing to stay the course. Members of the jury, aside from being the ultimate judge of the facts in this case, you have another very important job. You get to be the judge of the witness's credibility. You get to decide who you do and who you do not believe, whether their testimony is truthful and sincere. And so when Dr. Miller was on that stand and you heard how inadequate his investigation was, I want you to remember that when you pray. Now, Ms. Beckett bears the burden in this case. The burden to prove to you beyond a preponderance of the evidence that Hyatt Keeler intentionally discriminated against her. She has to prove this despite all of the evidence that goes against her claims. Evidence of the fact that she was investigated for fraud, that she was removed from cases, that she lost Hyatt Keeler's biggest client, that she didn't care what judges and juries thought. Evidence that she failed to stay the course. In a few moments, you're going to go back in that jury room and you're going to deliberate. And you're going to have this verdict form in front of you. And you're going to be thinking about all of the evidence that I just told you. You're going to be thinking about all of the evidence that Ms. Beckett failed to bring into this courtroom today despite knowing her burden. And you're going to remember this board right here. And all the facts on this board, you're going to use those facts, you're going to use the law, and you're going to use your common sense to find Hyatt Keeler not liable for both of these claims because they're not.